Meeting of the Compliance and Amendments Committee is now in session. We have the first item, please.
First on the agenda is call to order and roll call. Member Highland.
Present.
Highland present. Member Moss.
Present.
Moss present. Chair Kanata.
Here.
Kanata present. Just to note that on item number 4, file number 17090, the complainant submitted a withdrawal this morning. That's the only agenda change that I know of at this time.
Anybody have any issues with the minutes? No?
Next on the agenda, item 2, approval of the September 19th Compliance and Amendments Committee meeting minutes.
Okay.
I'll move to approve the minutes.
Second.
Okay. Any public comment on the minutes from the last meeting?
Hold on. Talk into the microphone if you want to talk. Yep.
Just a minor point, because this relates to another complaint I have with you that's not being heard today. It was my understanding that you don't issue minutes. Do you have minutes and they're on the web? Because
We do create minutes for the meetings, and they are posted online.
Oh, they are. So if I just go, because I missed it, because I saw some reference that you referred people to an audio tape.
We also have audio.
Awesome. But there are minutes that are.
Yes.
Well, very good. Thank you.
Okay, seeing no other public comment. Can we take it by acclamation?
That motion is passed without objection.
Okay.
Next on the agenda, item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Is there any public comment? Seeing no general public comment, public comment is closed.
And to restate, item number 4 has been withdrawn by the complainant. And just to provide a summary of the action that occurred, the department did provide some 20 or 30 emails with attachments of all the documents requested. The complainant still believes that there were some documents being withheld, but he could not state what they were. And this morning, he did withdraw the complaint.
Okay, great.
Next on the agenda, item number 5, file number 17075, complaint filed by Anonymous against Director John Ram and the Planning Department for allegedly violating Administrative Code, Section 67.25, by failing to respond to a media disclosure request in a timely and/or complete manner. Just to note, this matter was heard by the Compliance and Amendments Committee at our last meeting. We did ask that they go back and review the documents. I believe the issue was that the Planning Department provided emails via a CD which had attachments, and those attachments may or may not have been provided. It's my understanding that the parties met and they discussed the matter.
Okay, so there is an admitted violation of 6725 by the Planning Department. So the complainant, sir? Can you come up? I have a question for you, because I saw that in the documentation here that there was a whole list of other items that were provided. So my question is, have you received what you asked for?
Well, we have a rather unusual unusual situation here where the respondent agreed, where we met, and she agreed to provide the missing documents and agreed to mail me the CD. I received the CD, and unfortunately, I only looked at it earlier today, and it was blank. So I called her. I don't usually do business this way, and she just gave me what she promised to give me at our meeting a few weeks ago. Is it possible to hear this a few minutes later after the next item, or is that, could we? I'd like to look at it now. I just received it. I have it open in my laptop here.
We can do that. This also, since there was an admitted violation, everybody agreed there was a violation. This will go to the full task force for the full task force to rule. So, but yes, we can give you time to check this CD.
Sure, appreciate it.
Okay.
So what did you just say about the task force? I didn't understand.
So this item, because there was a violation of 6725, will be referred up to the full task force, so the full task force can make a ruling that there was a violation. This committee doesn't rule that there is or wasn't a violation. It's a full task force issue.
Yeah, it'll have a full hearing that, we normally have.
Another
full task
hearing.
force.
Yeah, but at that hearing, since both parties agree there was a violation, it can just be stipulated that there's an agreement that it was a violation, and that's the end of it. You can choose not to show up if you have nothing else on the agenda for that one, or are we asking everybody to show up?
In case other members have questions.
Okay.
So go ahead and, I believe the consensus is go ahead and take some time and review your CD, and we will take another complaint while you do that review, and we can decide what to do after you conduct your review.
Yeah, but just regarding the full task force, do I have the option of withdrawing the complaint?
You can always withdraw your complaint.
Before that hearing? Okay.
Yes.
Let me look at it, and I'll be here. And I'll.
Yes.
Okay, thank you.
Next on the agenda, so item number 6, file number 17092, complaint filed by Ellen Sang against John Ram, Ann Brask, and the Planning Department for allegedly violating Administrative Code, Section 67.21 and 67.25 by failing to respond to an immediate disclosure request in a timely or complete manner. This matter was also heard by the Compliance Amendments Committee at their last meeting. I believe there was an issue regarding a response to an August 16, 2017 IDR. It was requested that the Planning Department go back and research that item and respond to it. Okay. And I have not received any updates since then.
Okay, so I thought it was the 823 IDR that was the issue.
I'm not sure.
Okay, and again, planning admitted to a violation of being late. So I guess the question, Ms. Sang, is do you have what you're looking for?
Well, first of all, thank you for you ordering them. They did a while after that, but but I wanted to clear the two things that I believe is important. And the first thing is this is for the August 16 immediate request for two documents, and then they did not respond timely.
Correct.
And then they did not even respond to Sunshine's requirement to answer anything. But however, when before the hearing, the last September 19th hearing, just before, they submit something to Sunshine, and I didn't receive it, but I get it from online. And then was dated September 11. They claimed that she acting like a fortune teller. He claimed that so August 10, 6 days prior to my August 16 immediate disclosure, he already responded to my August 16 IDR. If I asking for the same thing, you can claim that, but it's totally different document and for asking for different day. And then they asking your committee to vote on my August 10th IDR, which is not even the subject of this complaint. 17092. And then he wants you to consider my two different IDR, which you make on different day for different document for this case. And then take away my right to file another Sunshine complaint against them for their untimely and non-responsive answer to my August 10th IDR. I just think that you should be clearly state that you cannot support this kind of misconduct. So I believe that this case should forward to the full board, and then they should be file violation. And then should clearly state that this case is this August 16 IDR has nothing to do with IDR August 10. It should be very clear. They submit something to you and to the online. If people don't look carefully, they are intentionally. It's just like you.
Yeah, this item is going to the full board
Okay.
because there's an admitted violation, but you still haven't answered. So, did you finally get what you were looking for?
Yeah, the two documents, after
Okay.
you order them, they did there. But
Okay.
there's two other issue I think is very important as well.
Okay.
Yes,
Thanks.
thank you.
And Ms. Silva, I just have a question. The last couple of times, definitely the last meeting of this committee, but I think the last couple of times, and maybe at a full meeting of the task force, you had stated that there were some issues in the office with responding, and they were being worked on. Has that stuff all been worked out?
Yes, we're completely caught up on all the requests at this time.
Okay, and not only caught up, but is there a system in place where you're not going to
Yes,
run into a situation like this? Because I remember there were at least 3 or 4
yes.
that, okay, thank you. Any other questions from anybody? Okay, so we need a motion to send it up. We found jurisdiction last time.
Yes,
we-
I
we-
believe the motion would refer to the full task force or I don't know if you want to provide a recommendation since it was admitted
Well,
that there was.
Can the motion state it we're referring it to the full task force and there was, and planning admitted to a violation?
Usually I would refer it up without any recommendations.
Right.
And I would note that it is the opinion of this committee that a violation occurred.
And was admitted to?
Yes.
Okay,
So, through the chair, so you can provide that in your summary
yeah, definitely.
before, I guess.
And it's my understanding that I will note that the planning department has since provided all the requested documents, and the complainant has agreed to that.
Okay, great. So who's going to make that motion?
Just before we do that, I've just been thinking out loud here, with especially the previous respondent. Let's say during our committee hearings, we go back and forth. The requester gets the information they want. And they say, "Okay, I'm good," even if a violation has been found, and they withdraw. What's the movement there?
Withdrawn.
So someone could withdraw at this point.
Yes.
And it doesn't have to go to the full task force.
Yes, but an official finding will not be made by the task force if they do withdraw.
I see. Okay. I just wanted the people making the motions to understand that as well. Okay.
I just wanted, as I told you, that those two issues are equally important to me.
Yep.
It cannot be take away my right for the other one. I
Yeah.
want to make that very clear.
Absolutely,
Thank
yeah.
you.
Okay.
Okay.
So, do we have a motion?
So a motion to
Refer to the full task
full
force.
task force.
I'll second that.
Okay. Any public comment on the motion? Seeing none? Do we need to vote or acclamation? Or since it's a motion, should we vote?
It's your choice.
Take it by acclamation?
This motion is adopted without objection. Next on the agenda, item number 7, file number 17112, complaint filed by Marvin Lambert against the Planning Department for allegedly violating Administrative Code, Section 67.21, by failing to respond to a public records request in a timely and/or complete manner. This is a new matter before the task force. Would you like to hear from the complainant? I believe we should.
Yeah, I know this. I looked at the documents and everything, and it's related to the other complaint that's going in front of the full task force, but we'll hear it here.
Yes.
Now, okay. Sir?
Yes,
Mr. Lam- oh.
thank you. Yeah, I wanted to just make clarification. So in total, I have 4 complaints before the task force. 3 of them basically are identical. They are about client withholding information, claiming client privilege. 2 of them are against the Parks Department. 1 is against planning. The one against planning is what we're hearing today. one of the park department ones has been referred to the full task force's waiting schedule. It's not, I guess, not an immediate concern, but I'd suggest somehow all three of these be grouped together or something, because the documentation and what I plan to say now will be identical for all three of them. So shall I make my statement about this?
Yep.
So did we ever come to Victor? Do we ever come to a conclusion about whether we could bundle cases or not? I know that we had run into some controversy.
As long as the parties agree, it's not an issue. We can call them and hear them together. Usually it's similar subject matter, similar department, but
Would both parties have to agree to hear them together? The complainant and the respondent?
I don't think the departments would disagree with that, but I don't foresee a problem with it.
But this one is, so the other ones are against parks, and this is the only one against planning?
Yes.
So the thing is that I think that when we just kind of smush them together, you don't get necessarily a smushed up amount of time to make your case. And so if you have it against two separate parties, you may want to keep those separate.
It's fine with me. I guess I just suggest that it all get funneled.
We can hear them on the same day so that we can hear it, but I believe the city attorney has advised in the past that attorney-client privileges, there's no guideline for how to address that, and it needs to be taken on a case-by-case basis, depending on the facts.
Through the chair and to Member Moss, in the times before you guys joined where we were forced to combine multiple cases, we actually did give them 5, 5, and 5 and said take as much of that as you need. Typically, they only take about 6 or 7 minutes, and then we would move on. So the options were there. But just to keep everyone on point, the discussion was essentially the same. So,
Okay. So why don't you let
I'm good with all
let us
that.
know what this one's about? And
Fine, okay, so this is just directed planning, but could be any. So with regard to this withholding, and they've all admitted that, if that's the correct term, that information was withheld per the claim of client-attorney privilege. So that's been acknowledged, that there is information withheld in all three of the cases. So what I'd say in terms of analyzing this, I see no basis for this. The first question I would have for the task force is, who is the client? That's not even specified. Is it the city or is it the individual employee that created the document? If it's the city, I see no evidence of any process that they went through to withhold this information. If it's the employee, I have to ask if there's possible coercion there. Because when I read the statutes, there I find three bases for withholding information subject to this privilege. Number one, if there's pending litigation. I'm not threatened any litigation. There is no pending litigation. I don't even know who that would be against. I don't think I could reach the employee, or I don't even want to imply in any way that I would be threatening a lawsuit. I don't think anybody in this situation could reach the employee with a lawsuit. So it could probably only be the city. The second thing is, the second basis for withholding information is if disclosure of the document would violate state or federal law. Well, I can't see that here. And the third one is if the attorney claims a work product exemption, which is, I'm glad they didn't make that claim. Although one of the attorneys, I believe it was the Park Department attorney, did mention that blueprints would have to be withheld. I suppose there's some copyright thing, which is, if you get into this project, that's laughable because the specs that were on the source project that's precipitated all this was like it was written on the back of a napkin. So those are the only three bases for withholding information. I don't see any of those anywhere close in this. Now, the other thing is Section 6726 of the Sunshine Ordinance, withholding is discouraged by law. Documents may not be totally withheld unless everything in them qualifies under the privilege. Otherwise, the document must be released with redaction of that portion, which would be subject to the privilege. And then finally, attorney-client privilege is waived if anything is disclosed to any third person. Effectively, the information has to be in other people's hands. So I would claim even if the attorney-client privilege withstands, which I don't think it would, then you'd have to say, well, has it in effect been waived because other people have, there's an asymmetry of information. I'm the one that doesn't know what's going on here.
Okay.
So that concludes it. Thank you.
Thank you. Ms. Silva.
Christine Silva, planning staff. On Thursday, October 12th, the complainant sent an email submitting a records request for email correspondence as related to one of our staff, Scott Sanchez. This request was in response to a previous request production that inadvertently included an email message between planning staff and our city attorney. Later that day, the complainant submitted a follow-up email amending his request to also include Deputy City Attorney Victoria Wong, and those two exhibits are included in your packet. Staff sought out the records and determined that any responsive records were our attorney-client communications and therefore protected from disclosure. In response, staff emailed the complainant stating that the previously produced email included attorney-client privilege communications and was produced inadvertently. Staff further requested that the complainant destroy all copies of that previous communication and replace those with a PDF that omitted the communications, which was attached as a PDF to the email message. Lastly, staff indicated that planning searched for the responsive records and would not be providing records that constituted attorney-client privileged communications or work product pursuant to State Code 6254K and 6276.04, and that no records would be produced in response to the complainant's request. The complainant alleges that planning is in violation of Admin Code 67.21 by failing to respond to a public records request in a timely and complete manner. That is incorrect. With respect to timeliness, as set forth in Admin Code 67.21b, planning's response to the complainant occurred on the same day as the request was submitted. As such, the time frame of staff's response was well within the 10-day window. Furthermore, the complainant is mistaken in asserting that planning failed to respond in a complete manner. Staff's email to the requester identified that a search was conducted and also that planning would not be providing records that were protected from disclosure, specifically attorney-client privilege communications or work product, citing State Government Code 6254K and 6276.04. There is no further requirement to justify the withholding beyond stating the exemption. Pursuant to Admin Code 67.21K, the Sunshine Ordinance provides that release of documentary public information, whether for inspection of the original or by providing a copy, shall be governed by the California Public Records Act, in particular is not addressed by the Sunshine Ordinance. The Public Records Act allows an agency to decline to disclose records the disclosure of which is exempted or prohibited pursuant to federal or state law, including but limited to provisions of the Evidence Code relating to privilege. And then California Evidence Code Section 954 protects from disclosure communications between attorneys and their clients. You can also see State Code 6276.04, which cross-references the Public Records Act. For the foregoing reasons, we respectfully request that you find us in compliance with the Admin Code and dismiss this complaint. Happy to answer any questions.
Thank you.
Through the chair. Victor, is what she just read, is that in our packet? And if not, it should be for
Was
the
that
next.
included in your memo?
Yes, that's pages 306, 307 of your packet, all the way to 315.
It's in my packet.
Yeah. Any questions? Member Moss, any?
Through the chair.
Yeah.
So, we have this attorney-client privilege thing come up, past cases, and I know sometimes we grapple with, well, how do they justify it? What do they have to do, not have to do? So it seems like, based on what I'm seeing here, it's clear cut. They don't have to provide anything. I'm not quite sure I remember it that way. That's something I would like to push up to the full task force as maybe a point to consider, maybe part of your summary. It might be black and white. Member Moss, do you see anything?
Yeah, I think what we can do here is just get all the facts out, determine what all the facts are, and send it up to the full task force where we have the city attorney there, so that we can get into, at least have some legal opinions on withholding information by claiming attorney-client privilege, and how is it determined that that's a valid reason?
Yeah, is there a litmus test or not? And then that's the first piece. And then going back to the first assertion that it was timely, can we agree upon that? I mean,
I don't know. That's so.
okay.
Mr. Lambert, could you come up, please? I've got a few questions. The timeliness issue.
Yeah.
So when...
I don't recall that. Victor would have, or I didn't bring my original complaint.
I believe,
but I don't recall that.
it would be timely if it still has not yet been provided and they were required to do so. So the
Okay.
response was timely,
But they said they didn't have anything because of
Yes.
time. Okay, so
but
let's
if
not...
there are documents to provide and they haven't provided,
Right.
it would not be timely at this point.
Correct, okay. So as I went through this, I saw a whole bunch of dates. The first one was on October 2nd. Was that the start of this, where it said a request was sent to planning about the Cottage Row Zen Garden project?
Probably so, yeah.
So that's how it started. Then on the 12th, and then planning then what the packet says is planning allegedly inadvertently disclosed to you documents that were subject to attorney-client privilege. So you got some
I
documents
got
that...
some there, yeah.
Okay.
Slipped
And then
through.
in October, I just want to make sure...
Yeah.
And then on October 12th, you sent another request, and that was for additional records. And what happened with that one?
Well, is that the one that they then provided either, I mean, I don't have all these records with me, although I guess you have a copy of all of them, and between keeping this straight from the Park Department one.
Okay.
But at one time, they said they had nothing to, one of them said they had nothing to give me because they did have stuff, but they were withholding because of the attorney-client privilege.
Okay, so this one, the October 12th one, mentioned Scott Sanchez was part of the COA determination process.
Yeah.
Who is Scott Sanchez?
He's a zoning administrator
Okay.
at planning.
Okay, so you requested records from him also?
And then I contacted him.
Okay. And then on that same day, I have here that planning via Ms. Silva responded to you and saying they received the email. They mentioned the emails that had attorney-client privilege, and then they mentioned that they searched the records and don't have, and anything they have, they're withholding because of attorney-client privilege.
Yes.
Okay, so that's correct.
Yeah.
Ms. Silva, do you agree to that? Those list of facts, okay. I mean, I don't know, I don't think I don't feel, one second, I don't feel comfortable making any recommendations on attorney-client privilege until it goes up to the full board.
Agreed.
Okay, so, and you, go ahead. Sir.
Is there an additional item that came out of this? So it sounds like evidence was destroyed from Ms. Silva's testimony that somebody requested that something be pulled back, and then it was actually deleted. So was some
Ms. Silva, come up
was
to also.
something actually destroyed here?
I didn't hear that, but yeah, what I heard was the only thing I heard about taking, or they asked you to destroy the document that had attorney-client privilege.
That's correct.
Okay.
They did.
Okay.
And I did not.
I don't care. That right now, that's not not important to me right now. So, Ms. Silva, was that the only?
That's correct, yes.
Okay.
Okay, well, thanks for clarifying.
All right, so,
I believe there would be a recommendation to find that the task force has jurisdiction.
jurisdiction, correct?
The requested records are public, even though they were not disclosed.
Right, exactly.
And I assume it's to refer to the full task force with no recommendation.
Can I just say so moved?
Sure. Second it?
Second.
Okay, any public comment on the motion? Seeing none, take it by acclamation.
That motion passes without objection.
Good.
Moving back on the agenda to item number
5.
5, file number 17075.
We're back on item 5, you said?
Yes.
I confess to being confused about the procedure here. So if I haven't had a chance to go through all the files, that's the simplest way to put it. If I say tentatively, I'm going to give the respondent the benefit of the doubt, but later on, before the full task force hearing, should I discover something missing, is that an opportunity to raise that
Through the
at
chair?
that point?
Yes.
I think what Victor's going to say is, if you like, we can continue it to the call of this committee to this chair. In the interim, if you read your material, find out that you are happy, you can still withdraw a day, 2 days, 3 days from now. If you find something, if you want to have it come back and go to the full task force, you can let Victor know, and we can proceed and do that.
And when do you need to know that?
As soon as possible.
Victor, was that what you were going to say, or you had another idea?
You can go any direction with this one.
Right.
So
So
we
it-
can continue it, or we can just refer it up immediately.
So what I was going to say, so if you had gone through it and found all the documents, if you withdraw, then there is no record, there would be no record of planning having not been responsive in a timely
No violation
manner.
on record, yeah.
Correct. There would be
Yeah.
no violation on
Okay.
record for this. If you don't withdraw, we can schedule this for the full task force with telling the task force that there's an agreed-upon violation, because planning agreed they weren't responsive in a timely manner. And at that meeting, if you got everything else, that's it. You just state, yeah, I got all my information, they had this violation of timeliness, and that would be it.
Yeah, and-
If you withdraw, though, there's no opportunity to have a violation.
Yeah. And what is our best guess as to when the next full task force meeting will be?
I don't make predictions at this point, but
But
it
is-
is several months.
Right.
I mean, it wouldn't be the December meeting.
No, I would guess February to.
We have a pretty big
March.
backlog, so it'll be 2-3 months.
a few months. All right. Well, let's do that. Let's put it in the hopper for the next task force meeting. That should give me plenty of time to completely review all the records, and the options are to withdraw any time before.
You could withdraw prior to the meeting being scheduled. However, in any case, I would like to have some kind of communication as to whether or not you believe you received all your documents or not for the file.
But when?
If we do go to the full task force meeting, I would
I
like to
can
know
give you a
whether
few
or
weeks'
not you
notice if
believe.
you're not going to meet until February anyway. So I can certainly know.
Victor, what is the current deadline for people? Like, I thought we had
5 days prior to
so
the meeting.
five. So I guess it's 5 days prior to the
5 days.
hearing.
Yeah, 5 days
Right.
prior to the full task force
When it's scheduled.
meeting.
But I would like to get an indication of whether or not the documents have been provided as requested.
So you'll get a notice saying this is going to appear on the full task force, and you'll also get a date saying please submit all materials 5 days before this date, and then so that'll probably amount to about 10 days, 2 weeks notice, I'd say overall.
Yes.
Roughly, yeah. And I think what Victor's asking is if you make any decisions or if there's any advance in the case, please communicate that to Victor in the interim.
Yeah, with 2 weeks' notice before the full task force meeting should be plenty of time, and you don't think it's going to happen before January 31st at this point, right? No.
It's
So that's
doubtful.
a couple months away. That's
Yes.
plenty of time for me to do what I need to do. Thank
Okay.
you.
So a motion to refer to the full task force?
Yeah, refer to the full task force. Very similar to the other one where I will bring up that there's an agreed-upon violation of timeliness, and then if it's unless it's withdrawn, and
You won't have to do anything if it's withdrawn.
right, exactly. So the motion is to refer it up to the full task force.
Who would like to
Second it,
make-
yeah.
Who made the motion?
Member
Highland?
Highland?
Yep.
Seconded by Member Moss.
Yep. Take it
Public
by
comment?
a public comment on the motion. Seeing none, can we do it by acclamation?
The motion is adopted without objection.
Okay.
Next on the agenda, item A, announcements, comments, questions, and future agenda items.
Does anybody have anything? Victor, do you have anything?
No, I do
Oh,
not.
I have a question.
Yes.
Has a date been decided for an extra full task force meeting?
I have not heard back from Chair Wolf. I'm hoping for December the 16th, as January is a little crowded. But I will communicate it to everyone once I get confirmation
Okay.
from the chair.
December 16th.
16th is Saturday. It's not-
I must have the wrong. I'm working on next year also.
Maybe you mean the 18th, 19th?
December, most likely it's we will replace the EOTC meeting on the 19th,
Okay.
if we do it.
All right.
Okay.
And then the other option was the January 16th date, which I'm hoping not to do that date, because it's right after a holiday.
It's a holiday, yeah. All right.
And just so you know, there are 3 or 4 items that have been referred to Compliance and Amendments Committee. However, they're relatively simple in that we are just confirming whether or not documents have been provided as requested by the task force. Those shouldn't take more than a few minutes each.
And what about the issue of having prior members come in to what issue were we discussing?
There was a meeting, we were trying to get a meeting together to discuss the issue of donations of $100, whether they need to comply with the entire.
The entire ordinance or just
Yes,
67?
and that is a little bit more difficult than it sounds, and I'm waiting for the Chair Wolf to take the lead on this one, as he's more familiar with the parties than I am.
Okay.
But that is, that one's going to take a while, I believe, as it's not a clean-cut issue.
Okay. That's it?
And the next meeting of this committee will be, I believe, in January.
Right.
I believe, actually, the 16th date. That you would have been pushed if the full board came to that date.
Right. Okay.
There's no other information I have at this time.
All right. So who's
Motion to adjourn?
Seconded.
By rise and vote, that motion is passed. The meeting is adjourned.
all right.